Hello guys, I hope you all are doing well. Yesterday I received this comment from one of my subscriber asking me to explain everything about pleading and drafting in detail. Also asking me to provide guidance to write plaint and written statement. So in today's video, we are going to talk about pleadings, drafting and conveyance in detail. We are going to cover everything from basics to advanced. And I want to tell you that if you have any kind of question regarding drafting, if you want any explanation of legal topic, then you can also send me the comment. I'll make a video on your comment as well. So let us continue with our video, which is on pleading, drafting and conveyance. So let us first understand this. Pleadings are of two types. You can say civil pleading and criminal pleadings. Civil pleadings are mostly related to those matters which deals with compensation and damages. On other hand, criminal pleadings are those pleadings which are related to mostly fine and punishment related matters. And if we talk about the examples of civil pleading, here are the examples. For instance, plaint, written statement, writ, petitions, application, civil appeal, civil review, civil revision. These are the examples of civil pleadings. On other hand, if we talk about criminal pleadings, it can be complaint, bail application, criminal appeal, criminal review, right, etc. So those matters which are related to fine, related to punishment are the matters of criminal pleadings, and those matters which are related to compensation and damages are related to civil pleadings. Now some matters includes both, right? For instance, if we talk about a case of defamation, or if we talk about the case of check bouncing, you can institute suit as well as you can also institute criminal case, right? So it basically depends upon the party's intention. If party wants compensation from the opposite party, then party can go and file civil suit. And if party wants other party to get punished, to get fined by the court, then party can approach in criminal court and asking for such kind of relief. Alright. Now next thing that we have to understand is the name of party, because name of party changes with respect to the proceedings. So if we talk about civil suit, the one who files the case is known as plaintiff, and the one against whom the case is filed is known by the name defendant. If we talk about petition, the one who takes the action or files the petition is petitioner, and the one against whom the petition is filed is the respondent. Alright, same if we look at in case of appeal, the person who files the appeal, whether it is criminal appeal, whether it is civil appeal, the person who files it will be known as appellant, and the person against whom the appeal has been filed will be known as respondent, right? Now in case of complaint or criminal cases, the person who files the complaint is known as complainant, and the person against whom the complaint case has been filed is known as accused. Alright, sometimes complaint is not filed in criminal case, directly case is initiated from FIR, so the victim party will become the prosecution, and the person against whom action is taken is known as accused. Alright, keep this in mind that name of the parties changes, but the nature remains the same. Alright, for instance, plaintiff, petitioner, appellant, complainant, these are the people who institute the proceedings, and these are the name of the parties who defends their case. Alright, now if we talk about the example, as in this video we are going to cover drafting and pleading in detail. So this is the example through which we are going to understand. Alright, these are two people, James and Lily. So let us say that they have certain dispute. Alright, let us consider it related to property. So in order to solve that dispute, James has to file plaint in court against Lily, and in the answer to that plaint, Lily has to submit written statement to the court. Now what court will do? Court will accept the plaint and written statement on behalf of party, and court will examine these documents, and upon that court will frame the issues. Alright, and these issues are the disputed portion which court will decide by conducting a civil trial. Alright, so that is why plaint and written statement are very important, because on the basis of plaint and written statement, court will frame issue. So if there is any error in plaint or if there is any error in written statement, issue will not be framed accordingly and party will suffer. Right? So being an advocate, it is very important for everyone to draft plaint and written statement accurately. Alright. Now let us go further. Let us understand some points which will help you to write plaint accurately. Alright, these are the points that you have to follow while writing the plaint. One by one we are going to cover them. First point is state the fact and not the evidence. So when plaint is being prepared, one thing that we have to note, that we have to just state the facts, means mention the facts only. Do not tell about the law or evidence. Right? Court will take care of it by itself. Second, fact should be in concise form. Do not make it lengthy for the court. Alright, make your fact concise so that it will be easier for the court to understand it. Third point, every separate fact should be given in separate paragraph and numbered consecutively. Means if you want to tell the court about 10 different facts, it must be stated in 10 different paragraphs, and every paragraph will be numbered, alright, accordingly. If you are going to mention any date, any sum, any number in your plaint, then you have to express that number in words as well, right? You have to mention the words. For instance, if you are mentioning a particular number of some, let's say 10,000, so you have to write the word 10,000 in words as well. You have to mention the number as well plus words, alright, in bracket. Then while writing the plaint, you have to mention the name of the parties and address accurately. There should be no error in the name of party and the address. If there is any error, it will be a technical error and it can be corrected further, but it will cause delay. Right? Then thereafter, this is the important point, cause of action should be mentioned. Now, many of you, if do not know what is cause of action, then I have made a separate video on cause of action. You can check out the video. I'll provide the link here, or you can check the description box for the video related to cause of action. Right? Now, next thing is fact that court has jurisdiction should be mentioned. So in the plaint, it is to be mentioned that court has jurisdiction, and you have submitted court fee related to plaint. Then affidavit should be attached with the plaint. List of documents and the witness will be provided, and wakalatnama should be mentioned. Alright, wakalatnama should be presented by the advocate. So these are the things that we have to take care when we are writing plaint. Now on other hand, if we talk about the important points for written statement, so some of the starting points are same. For instance, fact should be stated, not evidence, and fact should be in concise form. Every paragraph should be separate and numbered accordingly. If you are mentioning any date, some number, then it should be mentioned in words as well, and name of the party and address should be accurately. Now these are the points which are only related to written statement. For instance, in written statement, defendant will provide his defense. For that purpose, defense has to deny each and every point of plaint specifically. Alright, keep it in mind that every point will be denied by the written statement by the defendant. Right? If defendant forget to deny any important para or any fact, then it will be presumed to be accepted. So it is very important to deny each and every point. On other hand, if a right related to set off is there, then defendant can claim it. Defendant can also mention counter claim. Now set off and counter claim, these are the rights which are available to the defendants only. If you do not know what is set off or counter claim, comment me. I'll make a video on set off and counter claim explaining them in detail. Then wakalatnama of defense advocate should be there, list of document and witness should be mentioned, and affidavit should be attached. If you do not know how to write affidavit, I have already made a video. I'll provide link in the description. You can check out that video as well. Even if you do not know how to fill wakalatnama, I have made a video on it. You can check out, link is in the description. Now let us understand the format of plaint in civil suit. So when party has to file plaint, first party has to mention the name of the court and the place at which court is situated in the first line. Then party has to mention the suit number and the year in which the case is to be filed. Now remember, the space for suit number should be available, but you have not to mention it because it will be mentioned by the registrar. After this, we have to mention the details of the party. So first we'll mention the name of the party and the address of the party, and this party will be plaintiff, which means this party is the party who is interested to take action, civil action against the defendant. Then versus, and after that we have to mention the name of the party and address of defendant. So we have to mention at the right hand side that this party is plaintiff and this party is defendant. Once if you had mentioned all the details of the party, keep it in mind, this should be accurately mentioned. If any error is there in the name of the party and address of the party, then it will be a technical error and it must be corrected. Otherwise, court will not proceed. Right? Then thereafter, the subject of the suit should be mentioned. Now, for which the suit is being filed, whether it is related to recovery of money, whether it is related to defamation, whether it is related to any civil action, it must be stated here. Right? Thereafter, we have to mention the paragraphs for which the action is, for which the plaintiff is taking action. There can be any number of paragraph. For just explanation purpose, I have mentioned 9 para. You can mention as many para as you want, which is suitable to your case. In order to understand what to write in this para, I'll tell you one important thing, that there are 2 categories of paragraph. Alright, one category is related to factual para or facts related paragraph. The other paragraphs are legal paragraphs. Alright, so keep it in mind, there are 2 categories of paragraph. Factual paragraph, yeah, paragraph related to facts, and legal paragraphs. Right? So in fact related paragraph, we have to mention everything about cause of action, such as the circumstances which lead the plaintiff to ask for the relief from court, right? So as I said, cause of action is very important, and if you do not know what is cause of action, I have made a video. Link is provided in the description. You can check out the video. I have explained everything about cause of action. Alright, so you have to mention the relation between the parties, the history between the parties, the facts, the story, and ultimately you have to mention the cause of action between the parties. If there is no cause of action in the plaint, then plaint will be rejected. Plaint will not be accepted. Alright, keep it in mind. Then thereafter, when you have completely mentioned everything about the facts as well as the cause of action, then you have to mention the legal paragraph. You have to mention para in which you have to tell the court that court has jurisdiction and that party has submitted court fee, that valuation of suit is under the pecuniary limits. Alright, and there can be many other legal paragraphs. For instance, suit is not barred by res judicata, or there is no other case which is pending between the party, right? Res sub judice. And at the end, there will be a prayer clause. So basically, what remedy party wants from the court and what relief court will grant. So you can mention the prayer clause, and in prayer clause you can mention what relief party required. After completion of this, at the left hand side you have to mention the place and date, and at the right hand side you have to mention the signature of plaintiff, and then verification paragraph in which you will mention that how many paragraphs are related to factual paragraph or fact related paragraph and are true by the knowledge of party, and how many paragraph are based on the advice of the advocate and believed to be true by the party. So this is the verification part, and after completion of this, then at the left hand side you have to mention the place and date, and at the right hand side you have to mention the signature of plaintiff. Sometimes you can mention the signature of party as well. Alright, and if we move further and if we talk about the format of written statement, then it will be similar to the format of plaint. First you have to mention the name of the court and then suit number and the year of filing the plaint. Then you have to mention in the matter of, and then you have to mention the name of the plaintiff and versus, and then name of the defendant in a single line, right? And then you have to mention the subject of the suit. Everything will be same. And when we talk about the para, here also there are two categories of paragraph, one related to facts and other related to legal. Alright, other related to legal para. So if we talk about fact related para, obviously defendant will specifically deny all the facts mentioned in the plaint. So being a defendant will deny all the statements of plaint, right? Keep it in mind, denial must be specifically, means if there are 5 paragraph in the plaint, you have to mention 5 paragraph and you have to deny each paragraph accordingly. You cannot just mention a single paragraph and tell the court that you are denying everything, right? You have to deny specifically. It means para by para you have to deny the facts of plaint. Then thereafter, if defendant wants to claim any set off or counter claim, alright, defendant can do so. So set off and counter claim are the right of defendant. If you do not know what is set off and counter claim, just mention it in the comment. I will make a video on your comment. Then thereafter, there are legal paragraph, and these paragraph are just like those paragraph as we had discussed in plaint. So in this, defendant will tell the court that court has jurisdiction or court does not has jurisdiction, because defendant wants that court should not take the case, and if valuation is not done properly, court defendant can mention that, and defendant can also mention the period of limitation that case has been filed with unreasonable delay. And then at the end, defendant will ask the court for the prayer. Obviously, defendant will ask for the prayer, dismiss the suit. Then thereafter, at the left hand side, you have to mention the place and date, and at the right hand side you have to mention the signature of defendant or his advocate. And then same, the verification paragraph will come, where party will mention that how many paragraphs are related to their own knowledge and how many paragraphs are related to the advice of advocate believed to be true. And then thereafter again, place and date will be mentioned, and at the right hand side, signature of defendant and the witness and the advocate will be mentioned. So these are the formats of plaint and written statement. I hope you liked this video, and I had tried to cover everything in this video. Still, if you have any question on any point, you can mention it in comment, and you can check out other related videos related to cause of action, affidavit, wakalatnama. All the videos link are provided in the description box. If you want to join live batch for drafting or for judiciary, you can contact on this website, which is anuragroylegal.com. If you like this video, do share it with your friends and subscribe for other related videos. Do not forget to hit the like button. I'll meet you in another video. Till then, goodbye.